Good afternoon or good morning, wherever you are. It's a pleasure to be here with you today. I'm Judge Rosemary Collins, recently retired. I was a circuit court judge in Northern Illinois, where I worked for 30 years on the bench. And I did a lot of things on the bench involving families and child custody. I was the presiding judge of our family court. I was the presiding judge of our domestic violence court. And our court did a lot of innovative work in domestic violence cases and working with victims of crime and victims of domestic violence, so much so that we were designated as a national mentor court by the Department of Justice. I'm really happy to be here with you today because, deciding child custody is one of our most important jobs that we do, whether it's as a judge or whether you're an attorney in the court or whatever involvement you have in the court system. We know how important the children are and what an important decision it is. So it's really important that we get into this material because it can help us make us better decisions. As I said, I'm from Northern Illinois. I had the privilege of meeting Professor Orloff and working with her probably for 6, 7 years now. Professor Orloff?
Good morning or good afternoon, everyone. Thank you for joining us today. I'm Leslie Orloff. I direct the National Immigrant Women's Advocacy Project at American University, Washington College of Law, and I'm very happy to be here today. These cases, we do a lot of technical assistance for family lawyers and judges across the country on the intersection between family law and immigration issues and issues that arise in cases involving immigrant domestic violence and sexual assault survivors, but also immigrant children. And many of you may know me more for my work in the immigration field around VAWA and T and U and SIJ, but I actually started my career as a family lawyer and had represented and went to trial on 800 cases of immigrant victims of domestic violence, mostly domestic violence and child abuse, mostly custody, almost always custody, often sometimes on a custody case, often in protection order cases, and sometimes in divorce cases. And so this topic is near and dear to my heart, and I also want to be sure that you have legally correct information because the custody courtroom is one of those places where abusers can be very effective and typically are trying to raise immigration status to gain advantage in the custody courtroom when they're perpetrators of domestic violence and child abuse. And so that's what we're going to be talking about today. I want to thank our sponsors. This webinar is being sponsored by the Office on Violence Against Women and the State Justice Institute. So we're welcoming here today both judges, court staff, lawyers, and victim advocates, and others who've joined us. The opinions that are expressed today are those of they're mine and Judge Collins's, and do not necessarily represent the positions of the Office on Violence Against Women or the State Justice Institute.
So we've told you a little bit about ourselves and who we are and our background. So now we'd like to know a little bit about you. If you could just tell us what your background is. Are you a judge or court staff, domestic violence, family law attorney, child victims advocates, or other? Please write it in your chat box. We're not able to monitor if you raise your hand or if you do questions and answers. It's got to be in the chat box for us. So if you could do that, we sure would appreciate it so we know who we have here with us.
Elle, is there a poll that we're putting up?
Yep, I was going to launch it, but then I wasn't sure if you wanted it in the
chat. Go ahead and launch the poll.
Okay, I'll launch it.
I gotta have the poll if you can do that. Yeah, great.
So if those of you that did it in the chat box, if you could join us in the poll, that would be helpful. Okay. Great. Looks like about 75 or 80% of you voted.
Right. Great. That's wonderful.
So
we can't really know what the other ones are through the poll.
Okay.
But, maybe you can put in. Go ahead, Leslie.
Yeah. So about 41% of you are domestic violence lawyers or family lawyers and attorneys. About 32% are victim advocates or child advocates, and about 27% of you are other. And I see in the chat we've got immigration assistance, somebody from a DA's office, justice system advocate, different therapist, DV case managers, bilingual advocates, so immigrant rights organizations as well. So it's a nice mix of folks. Great. So go ahead.
So what we'd like to know from you are what are some of the questions about custody and immigrant survivors that you might like answered by the end of this webinar. And we have a lot of material that we're going to cover. We would like to cover everybody's question. So if you have any specific question, write it in the chat box. We'll try to get to it. And if we can't, we'll get back to you later if we can do that. We also have an extensive list of resource materials for you that we'll give you at the end of this webinar that will help answer your questions too. But if you have anything specific or an area that you'd like us to cover, make sure you put it in the chat box so that we can see if we can cover it. Okay, Leslie?
Sure. So we're going to start off by giving you some data on dynamics. And when we talk about dynamics of domestic violence experienced by immigrant victims, helping judges understand, I mean, if you're a lawyer helping the judge that you're before understand, if you're a judge, it's important to understand that, that these dynamics are going to kind of affect and shape what you're going to see in the courtroom in family court cases involving immigrant survivors and children. And one of the things that we see play out all the time in custody cases has to do with immigration-related abuse. And this was data that we did the social science research and found that immigrant survivors have a lifetime abuse rate of about 50%. And that rate jumps to almost 60%, or almost 3 times the national average, if they are married, their spouse or former spouse is a U.S. citizen. U.S. citizens in particular use power and control over the immigration status as part of the dynamic of domestic violence that is placed. So now you're going to see me try to do some technology. I'm laughing because I'm not so savvy, but I'm going to show you a video that was prepared for the Department of Homeland Security to educate their staff about the dynamics of domestic violence in immigrant families. We're going to hope. You see it?
No.
You don't see it? Elle?
No.
Now we do.
Michael, good to see you. How are you? How's Julie?
Oh, Julie's fine. You know Julie. Look, Gloria, I got your mail again, so.
I am so sorry this keeps happening to you.
Oh, no, it's not a problem. Seriously, I get to come by and see you, so.
Thank you.
Absolutely. Well, there you go. We'll see you later then.
Okay, Michael, see you. And say hello to Julie for me.
I will. Thank you. Bye-bye.
Okay.
Having fun with your friend?
You frightened me. Michael brought me the mail.
Well, is he the only one? Or are you sleeping with every man in the neighborhood?
I don't understand. I didn't do anything wrong.
Oh, no, you don't. I don't even know if that baby's mine. You know, I could have you deported in 2 seconds and take that baby from you. You speak to no one. Remember what happened the last time you upset me.
Sorry.
You better be sorry. This is my house and I make the rules. And now I'm not going to file those papers for you. You see this?
No.
This makes you mine. You won't be going nowhere, not working without this.
No, stop.
Happy now? This is all your fault. Why do you make me do this?
Mary?
So yeah, as Professor Orloff mentioned, this is a training video, and it helps for the Department of Homeland Security officers to start spotting issues that may be out there in the field. So what I was wondering, if you could put us in the chat, put in the chat box if you can, what issues have you seen, did you see in this video? So talk about some of the issues that you saw that came up, and then we'll talk about them. So just type it in the chat. Yep, control ripping up documents. That's right. You know, there's many things here. There's the threat of deportation. He says he's going to send her back. He's threatening to take your child, to take the child. He's threatening physical violence, and he actually does do physical violence to her. Threatens not to file the papers for her to get her status. And then he actually destroys her papers. But you can also see some of the points that you brought up, the isolation. He doesn't want her to have contact with any other people, that he's jealous and obsessive and controlling about what her behavior and what her contacts are with the outside system. So there's a lot of great issues that we see, you know, that are common issues raised in a lot of cases. But I want you to think too, as we go through this, how would you present that information to either the immigration authorities or to a court? How would you make sure that they understand what's happening here? Because unfortunately, we don't have videos in our court cases. You probably don't have a video from your clients, but that information has to be relayed. And it is very common, as Danny says, it's very common. And so we need to be able to relay that information in a way that gets the message across to those who make decisions.
And what's really important is you're right. These are places where there are no witnesses, but this dynamic is happening all the time. And we show you this because we think it's important for judges in custody cases to look out for these underplaying dynamics, and for lawyers litigating these cases and victim advocates supporting victims to not be afraid to raise this information in the custody case, because it is evidence of power and control. It's evidence that he is trying to manipulate her and keep her under his control. And that what we see is that when U.S. citizens and lawful permanent residents have that kind of control over their, or any visa holder spouse has the control over the other spouse's status, then over 70% of the time, that person either files and withdraws or doesn't file immigration papers. When they do file papers, there's a mean delay of 4 years, almost 4 years. This dynamic happens in about 65% of the cases involving immigrant victims. And as I said, the abuse rate, it's connected to the abuse rate going up. The other thing that we know is that perpetrators of domestic violence and sexual assault in particular are actively involved once victims file their immigration case, their VAWA self-petition, their U visa, their T visa case. Perpetrators are actively involved in trying to get the victims removed from the United States. They are calling up and making reports to the Department of Homeland Security, which is why DHS created the video so they could teach their staff not to respond when the tip is coming from someone who may be a perpetrator of domestic violence. And that you see all of these kinds of tactics. You guys got these all in the chat: interfering with the immigration status, destroying the papers, giving her missing information about the immigration process, and threatening to turn her over. So Judge Collins, what are some examples of things you've seen in the custody cases before you that might be in this same similar to what we're talking about now?
I did a lot of orders of protection, or protective orders, whatever you call it in your jurisdiction. And a lot of times what happens in those is that they say, if you go through with an order of protection, then I'm going to report you to immigration. So we often see where it comes out through another court hearing that there have been threats of deportation, threats of reporting to the authorities. They often don't allow them access to people that might help them. So many times immigrants will get connected with an agency that helps immigrants, and they have no idea that they're eligible for any relief at all, because their spouse has told them that you can't use the courts if you're not a citizen, that the police will take you away. So there's a lot of immigration abuse that comes out generally through testimony when we actually get a case in the court system.
So, and what's really important about this immigration-related abuse is that it's not benign. It is not something that happens in every relationships that might be, let's say, emotionally abusive. It coexists with physical or sexual abuse. It's 10 times higher in relationships where physical and sexual abuse is happening. And it may, in relationships where the victim hasn't told you about physical or sexual abuse, where this kind of immigration-related abuse is occurring, it may predict escalation. So it corroborates the existence of physical and sexual abuse, kind of like that old cut telephone cord used to when we had phones with cords. Threatening to file annulment is another tactic. People will file annulment instead of divorce to try to undermine the victim's immigration status. And so when we talk about these issues, they have an impact not only on the victim, but that when that kind of dynamic is going on, it also impacts the children, which is part of the point we want to encourage you to be making in the custody case before judges. Judge Collins?
Yeah, I think it's really important too that we understand this issue well, because we don't want this issue to be turned on the victim. The abuser's behavior is related to the abuser. So we don't want courts to think, well, if domestic violence affects children in this way, which it does, it has very strong physical effects on them. It can cause anxiety and self-blame. We see neurological effects on brain development and cognitive effects on children. So domestic violence does have an extraordinarily strong effect on children that can last with them for the lifetime. But the cure for this is not to take the child away from the protective or immigrant parent. The cure for this is to get the child some kind of assistance to deal with the trauma, and also to remove the offender who is inflicting this trauma on the family. So be careful for that, because we don't want immigrant victims to lose custody of their children because of the behavior of the abuser.
So
we're also going to talk, go ahead, Leslie.
No, I'm going to share with them a video that underscores what you were just saying in terms of how the abuse occurring in the house, sometimes not, we're talking about the physical, the abusive environment and the physical abuse of mom that doesn't necessarily touch children, theoretically, how it affects the children in the household. And then you can pick it up from there, Judge Collins.
Sure. Mm-hmm.
See if this works.
Well, we have the opportunity to do police ride-alongs to a domestic violence situation. And so this was actually the first call I ever rode along. It was dinner time, and they were having spaghetti for dinner. It was dripping down the walls, the kitchen table was overturned, and we had 3 children in the household. Looking at this whole...
Oops, sorry. Did I goof it? Sorry.
Well, we have the opportunity to do police ride-alongs to a domestic violence situation. And so this was actually the first call I ever rode along. It was dinner time, and they were having spaghetti for dinner. It was dripping down the walls, the kitchen table was overturned, and we had 3 children in the household. Looking at this whole situation at the time, we said, no evidence of physical harm, the kids are fine. We learned differently, of course. The boy in the corner was classic behavior that we see with kids who have had chronic exposure to violence. He would just completely zone out, numb out as things started to get scary. The 6-year-old little girl on the chair blames herself for what's going on, but actually it was 4 years later that we really appreciated who had some of the most profound or severe harm coming out of this situation, and that was the 6-month-old baby who was now 4.5 and had seriously injured another child in preschool.
It's literally the opposite of the way most people think about this. Most people think young children, they don't really understand what's going on and they're resilient. But the fact is, if anybody's impacted more severely, it's the younger child.
The brain is put together like building blocks in a sense. Those first blocks that go together are the more primitive area, the survival brain.
The brain develops from the bottom to the top and from the inside out. So that the normal development of the top part of the brain depends upon healthy development of lower parts of the brain. The top part of the brain, where you do all of your thinking, is the part of the brain that is most changeable, easiest to modify. But unfortunately, if a child has developmental experiences of threat and exposure to domestic violence, the lower parts of the brain will be impacted and they're harder to change as they get older.
He was never physically abusive, but he was verbally abusive. There was lots and lots of screaming in front of the kids, berating, putting me down, and they pretty much heard it all.
Children exposed to domestic violence, children who witness their parents fighting, literally are experiencing a state of fear. And when this happens, the systems in your brain that are involved in thinking at the top part of your brain are literally shut down. It changes the brains of these children.
My son has seen and heard a lot.
Changes the brains of these children.
My son has
trying to
seen
stop it.
and heard a lot.
Okay.
Okay, so I think it's important that we learn about this area and see how the behaviors of abusive parents really do affect children, because how many times, if you're an attorney or you're an advocate, do you hear not only the abusers say, well, the kids weren't involved, they don't know what's happening, but you hear that from the victims a lot of times too, where they say, oh no, the kids didn't know, he's a good parent. The kids don't know anything that's happening. And we know that that's a protective impulse on their part, but it really isn't true. The kids do know. And how it shows is in their behavior and in their brain. And so it's really important that we understand that this exposure to domestic violence has an effect on children, even if they're not right there at the time. They could be in a different part of the house, but they know what's going on. And this trauma that the children go through really does affect their further development. So the abusive parent's behavior has a huge impact on that. And they undermine the parent, they isolate the parents, they endanger fear in the children, and they do that in many ways, even in cases that you may not think of as traditional abuse, domestic violence cases. Like I had a case one time where a guy sat the kids down on the couch and threw their cat into a ceiling fan. And so that was a real clear message to these children what's going to happen to them if they don't follow his rules and behavior. And what happens in the court system, if we don't protect these children, if we don't say to these children, we want to protect you, is they lose all faith in the system also. They feel like there's nobody out there to do that. And the way you can protect a child is by helping the protective parent. And so that's why it's really important to understand what these behaviors are of the abusive parent and how we can turn that into a way to help children. Leslie?
Yeah, sure. And so what's really important let me just say one other thing, is that the other piece around immigrant girls as well, in addition to all of this issue about being in the home and experiencing and witnessing the abuse, we also find that from a sexual assault perspective, immigrant girls are twice as likely by high school to have suffered multiple incidents of sexual assault. And so you need to be aware of that as well. And some of that has to do with the immigration process. Like if a mother comes from, let's say, El Salvador and remarries in the United States, and they're living in a household with her new boyfriend or new husband and 5 of his brothers, and she brings her 13-year-old girl from El Salvador into that household, that's part of the problem. It can be rife for sexual assault, there are perpetrators of sexual assault who target young immigrant girls because of this immigration-related abuse and the fact that they believe that they can't report or talk. So going back to what we just saw, though, it's important to understand, as Judge Collins said, is that protecting moms abuse, and VAWA is gender neutral, so protecting the protective parent, which could be a mother or a father, is the way to protect children. And we've seen data with immigrant children that shows a real benefit when mothers begin to access protection orders and forms of immigration relief. So to the steps that an immigrant parent can take to be able to break free of these domestic violence relationships and taking their kids with them have to do with access to immigration relief. That if you don't solve the power and control dynamic around immigration, or you can't, it's a way to stop threats from deportation to be a tool that perpetrators can use to stop victims. And it's for that reason that we wrote the Violence Against Women Act immigration provisions. They were to protect victims, improve community policing, allow victims to report crime without fear of deportation, and enhance victim and community safety. And so the benefits of these, so when we talk about this, we're going to talk about how important it is to raise the dynamics we just showed you when we were talking about as part of the family law case, so that the judge can see the whole power and control dynamic and can issue orders that are going to both protect the child and protect the victim client. And when survivors, and also judges may have questions about how are you going to support the children? What kind of stability do you have as an immigrant? And we're going to give you tools to answer those questions today. But generally speaking, when a survivor applies for immigration relief, they're protected from deportation. They have a path to legal immigration status, a path to financial independence, and they get critically upon filing what we call VAWA confidentiality protection that both seals that record and notifies the Department of Homeland Security that this person is a victim. So when the perpetrator picks up the phone and calls and tries to turn the victim in, DHS won't respond.
So who's eligible for this immigration relief if you're a victim of crime? Well, just about anybody can be eligible. If you have a case that is you think you could get an order of protection on, then they're eligible for immigration relief. There's a broad umbrella of crimes that are covered here, including child abuse, neglect, murder, kidnapping, and there's all that you see listed here, but it's also important to understand that attempt, conspiracy, or solicitation to commit any of these crimes also provides for that relief. So this is a broad provision. So if you have a client and you think they might get relief, then check it out, because they would. And how do you check it out? Well, this is Leslie's magic tool here, which I love. I call this the magic shield, because if you don't do a lot of immigration work, or if you have a judge who doesn't understand the dynamics of immigration law and state court proceedings, then it can get very confusing with the alphabet soup of SIJS, U visa, VAWA. So this slide is, and you can find it online. This slide is a great tool when you have a client come in or a case before a judge, you can go to this and say, what might they be eligible for? And so you can hit the individual part of the shield, and that will give you further information about that. So this is really one of those important slides that you're getting, and I highly recommend it, because it can be confusing to just think of who can get what. And so this slide is an important way to help you go through that process, because recognizing what immigrant. Go ahead, Leslie.
Yeah, and I was going to say, we're going to hand out in the materials we give you, you'll have the link to this slide. And it was developed by the Department of Homeland Security and links to their websites. As to the video, go ahead.
Yeah, I was just going to say the video is Leslie's proprietary, has proprietary use of that from Homeland Security. They won't let anybody else use it, and so it cannot be passed out. So
they use it themselves, but I can't pass it out. That's correct.
Right. That's right.
Okay.
Because Leslie does a lot of training for them. So recognizing what immigrant victims, crime victims can qualify for, what their children qualify for, is really important. And this is just a list of what things they might be able to get. They might be able to get a U visa or T visa if they're sexual assault or stalking victim. Human trafficking, there are different types of relief available. And then, of course, for domestic violence and child abuse, there's a lot of relief available. And so you really have to sort out what relief is available, what might better serve your client, what do you want to apply for? Can you apply for them all? Are there certain time limitations? So it's an important process early on in your proceeding, if you can, to sort this all out.
And that getting victims on a path to legal status through one of these avenues is going to strengthen your custody case, because you're going to be able to explain to the judge that she has work authorization, or she'll be getting a driver's license in 6 months or something like that, that could be very useful. And so the other thing is it opens up, as victims begin applying for legal immigration status, it gives them access to public benefits. And we have a public benefits map online that you can use, where you can go in, pick your state, pick the topic that you're interested, let's say TANF, and it will take you to a state-by-state chart where it says this person's eligible, this person's not eligible in your state, and it gives you, it links to a document with all of the citations in it that you can link to as well. We do lots of training and technical assistance on the public benefits, but I'm going to leave it at that right now. So Judge Collins, how does a judge's knowledge of immigration relief for victims and their children impact custody decisions?
Well, it's really important, because just like you briefly mentioned, a judge is concerned about how a child is going to be taken care of, both economically and trauma-wise. So you need to know, can they qualify for services for mental health? And can they qualify for certain school scholarships? Can the children get medical aid or medical cards? And a lot of judges don't do this kind of work, so they may not know that. And so your abuser could come into court and say, you have to give me custody, because otherwise they can't get medical care, they can't enroll in the school system, they can't do this and that. So it's really important, because a judge wants to make sure they do a safe, protective order for a child. And so you need to know how these issues relate to that issue to make sure you do the right thing for the kid.
So what we're going to do right now is very briefly go through the major forms of immigration relief that victims qualify for, so that in your custody cases, you can explain it to the judge, and judges, court staff on the call, can recognize this when it comes up in the courtroom before them. So the first one is the battered spouse waiver, which, first one is the VAWA self-petition. First one historically was the battered spouse waiver. It was the VAWA self-petition, and this helps battered spouses, children, and stepchildren of U.S. citizens, as well as parents of U.S. citizens, and battered step-parents, and parents and children of lawful permanent residents. So anytime somebody's abused by their U.S. citizen or lawful permanent resident spouse, parent, or step-parent, you're looking at a case that is a VAWA self-petition. These cases take about 4 to 18 months for work authorization, depending on the type of case. And your family court orders, a judge in a protection order case, for example, could issue orders about, the existence of a marriage or existence of a parent-child relationship and abuse that could be helpful to these cases. I saw in the chat that somebody was asking about battered spouse waivers. So in the VAWA self-petitioning case, this is a case where the victim self-petitions for immigration relief, because they are one of the 70% plus where their abusive spouse didn't file for them. In the cases in about the 30% of cases, or under 20 some odd percent of cases, where perpetrators file, the victim gets a temporary conditional green card for 2 years that she's supposed to come back with her abuser and sign a joint petition at the end of 2 years. The battered spouse waiver allows the victim, it keeps her from being trapped in that abusive relationship for 2 years, and allows her to get her green card sooner by proving abuse and the validity of the marriage. These take 12 to 24 more months to adjudicate, and the same kinds of court orders would be useful. Lastly, this is a chart for you to use later, but it could be very useful in your custody cases, because the definition of domestic violence in immigration cases is broader than your state law definitions in your protection order cases, in your custody cases, and in your criminal cases. And that what your state law defines as domestic violence will fall into the left two columns generally. Battering, and then there are forms of coercive control that many state protection orders also cover. But immigration law is also available to help people where there's abuse going on, but it hasn't escalated to become coercive control or battering yet. Back to you, Judge Collins.
So U visas are available to victims who are victims of a qualifying criminal activity, who have been, are likely to be helpful in the detection, investigation, prosecution, conviction, or sentencing of the crime. So that's also a very broad definition. So you want to make sure that if you have a victim of a criminal activity, that you don't let people narrow that definition on you, because if you call the police, if you go for an order of protection, those things can all be considered to be helpfulness for the purpose of the U visa. And you need to have information about the crime, but that also is broad. Like if a victim is hit from behind, so they don't actually know who hit them, but somebody else may know who hit them, they possess information about the crime. So it's not like they have to actually identify who the perpetrator is. Leslie, what's the timeline for a U visa?
So the U visas, the timeline, it's not the visa itself that is the issue. It's how quickly they get work authorization and protection from deportation, which is running 4 to 6 years now, but is going to be shortening significantly in the future with the new bona fide process. So hopefully we'll see in the next couple of years wait times to work authorization, deferred action, maybe of no longer than a year. And then it could take 15 years to get the visa, but as long as people can work and safely live in the United States without threat of deportation, that really is, I think, an important part of the process.
Family court does play a role in this too, because your family court judge can often file the affidavit or fill out the affidavit. And so make sure you understand that so that you can ask your family court judge, because you don't have to get it signed by a prosecutor or by a police, because a lot of these cases don't go through the police system. So you can ask the judge to sign the affidavit also.
And you're talking
Special
about
immigrant juveniles.
Hold on one second. You're talking about the U visa certification, Judge Collins, correct?
Yeah, right.
Okay.
Yeah, right. Yeah.
Okay.
And there's a lot of information online about that. We're just briefly touching on these topics. So special immigrant juvenile status is another really important area that the courts have a real gatekeeping role here, because you have to apply for findings from a state court with jurisdiction over the care, custody, or dependency of a child. And so for this, you can get immigration relief for unmarried children who are under the age of majority under state law. So make sure you check about that. The day they reach majority is the day this door closes. So you must have your court's order and approval of this within the timeline. This is very important for the family courts to deal with expeditiously, because you want to make sure that you do it to get the relief that they're entitled to under the special immigrant juvenile status that they may not be entitled to other way. What's the timeline on this, Leslie?
These run about 6 months to 3 years, depending on the country of origin of the child. So they're much faster than the U visa process, for example. And then the last form of immigration relief that I want to tell you a little bit about has to do with T visas for victims of human trafficking. And there's actually T visas and continued presence for victims of severe forms of human trafficking. It could be sex or labor trafficking. It can be adults or under 18-year-old children. Under 18-year-old children who are victims of sex trafficking don't have to prove force, fraud, or coercion. Everyone else does. And victims must comply with reasonable requests for helpfulness in the investigation and prosecution of trafficking unless, and this is true for both sex and labor trafficking, the child is under the age of 18 or the victim has physical or psychological trauma that would impede their helpfulness or cooperation. These take about 12 to 18 months right now. And in all of these cases, findings by state courts can help build the record of proof of the abuse or the crime victimization for these victims and any relevant relationships.
All of these are really show the importance of your state court order, because in your state court order, you need a specific written order. I mean, you can get a transcript, but you need to have the written court order. And in that order, you want the judge to say exactly what they found. Is there a marriage? What's the status of the two parents of this child? Who is the parent of this child? Just say your dad is the natural born parent, dad is the adoptive parent. Make sure they say what the relationship is between the parent and the child. Make sure the court says what the facts are that have the evidence of abuse, abandonment, domestic violence, and set it all out specifically, because you have people who are reviewing these orders, the state court orders, that are not from that state. So they don't know what the law is. They may not know what's going on. And so the state court has to say, I'm deciding this under my state court and law. This is the section of law, and here's what the facts show, and then just have it laid it all out. And what you can do is make sure that you know what you want to be in that order, and then make sure you hit that in your testimony or presentation to a judge, so that they actually do have that information. They're not going to guess on it. So it has to be presented to them so they can make sure it's in their order. It's very important. So let's ask you now, what are the benefits for immigrant survivors and parents and their children who are crime victims based? What's their immigration relief? So I know there are benefits available. So what are they? If you want to type some messages there. But Leslie, I'm really asking you this question. What are the benefits?
So we did while people are typing, they are talking about lawful permanent residency status they can get. We did a survey to look at how gaining legal immigration status and going through the process of filing a VAWA and U visa. So what happens early on in the case when they get a work permit or when they get deferred, protection from deportation. And what we found was we're seeing some really dramatic impacts for victims. And we're including this data because this could be very useful to you in helping your judges understand in a custody case, or if you're a judge, helping you understand how being the first to tell somebody about immigration relief, how asking parties to come back and report to you after they've looked into a form of immigration relief for a child or a victim, how it makes a difference. And there's like an 114% increase. When people get a work permit and get protection from deportation, there's a 114% increase in willingness to trust the police. There are dramatic declines in immigration-related abuse that you see in the courtroom, declines in child snatching, declines in immigration-related threats to gain advantage in the courtroom as well. And people have more access to public benefits, as I discussed earlier. They might be able to get Medicaid or subsidized health care in ways that they couldn't otherwise get. And as victims file immigration relief, there's a 63% increase in their willingness to seek a protection order, a 60% increase in their willingness to file for custody, and that there's a 6-fold increase in their involvement with their children's schools. The children become more socially active, begin pursuing their own interests. By the time of lawful permanent residency, we see dramatic improvements in kids' grades and much less disciplinary problems and aggressiveness. There's the other thing that happens is there's a 300% increase in the ability of victims to get jobs that pay at least a minimum wage, a 43% more jobs that have health insurance and things like that increase, and a 77% reduction of sexual assault and attempted sexual assault in the workplace when victims have legal work authorization. And all of these slides will be available along with, we'll make sure there's information on continued presence in the materials that we provide you following the webinar. We're going to send you an email. We see a huge jump in English language ability or ability and interest in speaking English going up when victims gain work authorization and deferred action. And we see huge jumps in victims getting GEDs, associate's degrees, bachelor's degrees, advanced education, vocational education. And there's also improved community engagement. Judge Collins, how can attorneys help judges who are deciding custody cases with this information, with the kinds of information that we just covered?
This is really critical information because, judges try to follow the motto of many physicians do no harm, but we also want to actually help, and we want to help our children that are before us. So what you really need to do is let the judges know this information so that they know that the family, the protective parent, and the child will become more stable. They'll be able to financially take care of themselves. They'll be able to involve themselves with social services and with education, and they will. They'll be better citizens. It will help the children with their trauma. And so all that information needs to be brought to the court if they don't know that information. And the information that will provide you at the close of this case is a lot of judicial related focus. So that information can be provided to the courts in terms of a brief. You can give it to the judge in a brief so that they can look at that information and see it for themselves, that if what they want is a stable environment that will help this child deal with the trauma that they've had to experience, then they need to make sure these protections are in place.
Judge Collins, is there a place if you're, let's say the people on the call are working with a judge that might want more information about these issues around immigration issues coming up in the courts, human trafficking, for example. Is there a place where judges could go to learn from other judges?
Yeah, there is. There's a national judicial network. And on this national judicial network, it is judges from all over the country who have a broad range of experience with all these different issues, dealing with sex trafficking victims, dealing with labor trafficking, dealing with a lot of the crimes that we see that our poor children have to suffer, and they have innovative ways of dealing with them. And so it's a great way to get judges hooked up with other judges, to ask for information, to find out who's done what before, find out if there's orders that are already out there that you can just take and adapt to your system. So I highly recommend, and I'd be happy to talk to any of your judges that are interested in explaining the judicial network's role. So please tell them about the judicial network and tell them they are free to contact me if they have more questions about how joining. We have membership throughout the country, so it's a wide range of judges who are part of this group.
Yeah, and we'll send out a flyer or a letter at the end that you could forward to any judges that you think might be interested, that's signed by the 16 judges on the steering committee nationally. So far, the network has about 131 judges. So as we dig into custody a bit more deeply now, what we want to do is, NUAP did, we looked at all of the case law we could find nationally from the beginning of time to 2021 to identify trends in cases where custody cases where immigration status had become an issue in reported decisions. And we found that there were themes as to myths that were not consistent with facts, that there were courts that were basing their rulings on things that were not legally correct. But we also found in later trends, courts really understanding and not kind of going there when the abuser said, well, I may be an abuser, but she's an immigrant, so therefore I should have the kids because if she's an immigrant, she's going to be deported. Courts more and more are addressing that appropriately. And in this next section, we're going to give you samples of both. Today, 26 or 20, almost 25% of the U.S. population today is either foreign-born or has one or more foreign-born parents. 25.8% of children in the United States under 18 have one or more immigrant parents, and 22% of children in families with immigrants are U.S. citizens. So you see, these issues can come up in many, many cases. This is some of the data I referred to earlier. This is one of the first surveys we did. And what we found was that, just as Judge Collins talked about, protecting mom, who's a protective parent, in these cases involving immigrant victims, actually does dramatically reduce the co-occurrence of child abuse in these families. They also impact, there's less chance of reduced threats to children and reduced threats to kidnap children or take them away that occur when mom begins to get immigration status. And judges reported that in a time when immigration-related abuse was going, that immigration enforcement was going up, judges were seeing perpetrators of domestic violence raise immigration status in state court proceedings at greater rates of at least close to 30% higher in custody cases, in protection order cases, and in criminal cases, and almost a 25% increase, 23% higher in divorce cases.
So what you really have to look at is you have to analyze, is the immigrant status relevant to the issues in your particular case? Is it relevant to custody? Well, sometimes it may be relevant and sometimes it's not relevant. And it's really irrelevant to the bread and butter issues of, who can be a better custodian, who's a better parent, who's taking care of the child now. But it can be relevant if you're trying to, like Leslie was talking about, for those of you who are younger than us, the cut telephone cord was how we used to tell that there was evidence of abuse because they were holding people hostage. They weren't letting them contact people. Now, of course, there's no such thing as telephone cords now as much, but evidence of immigration abuse can be relevant to the issues of power and control. So somebody who's not filing their papers, somebody who's turning in their spouse for deportation, that's evidence of perhaps an evidence of abuse in a relationship. So it can be relevant for that, but it's not relevant to who's a better parent. Let's talk about some of these myths. I mean, you'll hear these in courts all the time. You'll hear them from attorneys that, this woman is going to be deported, so I have to have the child. And that's not true. The parent's more likely to flee the U.S. with the child. If you give her custody, and I say her because 95% or so of the cases involved women as victims, but they can be both ways. No, the U.S. citizens and lawful permanent residents are the ones who are more likely to flee. And that makes sense, doesn't it? Because you don't have the access to methods to leave the country unless you have U.S. citizenship or passports or a way to travel freely to and from the U.S. They'll often say this parent has no livelihood and can't work. Well, we know now because of what we heard that they can work, and you don't have to have custody of a child to file for immigration relief. So sometimes you'll hear abusers come in and say, if you want little Johnny to be able to, avail themselves of the great benefits of our country, then you have to give me a custody. But that's not true either. So it's important to know the myths and the facts.
So Judge Collins, there's a question in the chat where somebody's saying is if in a divorce or custody case involving domestic violence, how could an attorney object to a family court judge or opposing part attorney when they're trying to treat immigration status, when they're trying to raise the immigration status in a custody case? What would you recommend?
I think it's always good to be prepared ahead of time. So if I were you, I would have a packet of briefs about these particular issues, so that if you're in a case where you think this might come up, you already have a brief prepared and you can say, I object and here's why. And then you can give them this information with the footnotes to this presentation or to the materials that you'll get at the end of the presentation. So be prepared, because most of your state court judges, or at least a lot of state court judges, don't know what the immigration status means to the case. They don't know this information. So you're going to have to present it to them, but you have to do it by being prepared. And if you're not prepared, then ask for a break and say, Judge, I know this is wrong and I know where the information is. I need to go get it. Give me a recess for it. But don't let them get away with it. Fight them on all opportunities that you can.
And we have
So
materials
which parents
on
are the most likely?
Can I just say, we have
Go ahead,
materials
Leslie.
on our website on all of this, and we'll have you links to it. So we try to do all the research for you that you can kind of cut and paste from the things we've developed. We have a bench card on custody that deals with the myths and facts. It has all the footnotes and things like that. So, Elle, can you share the poll, please? And Judge Collins, you want to read it?
Yeah. Which parents are the most likely to be removed from the U.S.? Okay. Which parents are more likely to be removed from the U.S.? Is it immigrants with orders of removal, undocumented immigrant victims, victim parents, immigrants with criminal convictions, or immigrants with notice to appear?
Elle, do you have the poll?
Do we have a poll for this?
This one, it doesn't look like it got inputted. I'm sorry. Can they answer in the chat for this one?
Yeah, people are answering with the chat.
Okay. Sorry about that, Leslie.
No problem.
Well, Leslie, what do you think about this? Which parents are going to be the most likely to be removed?
And it looks like many of you are getting, some of you are saying A, many of you are saying C. It is parents with criminal convictions. And it has been that for years. Just before we, oops, sorry. I can't move my chat at the same time without moving the slides. I think there was something somebody said before everybody started putting it in the chat. What was it? If you could type it again and then I can, a brief. We don't have a sample brief exactly, but we can point you to materials that you can use. And the bench card is a good example. And we also have a chapter on custody with all the citations that you can crib from to write your motions. Okay. So the answer is criminal convictions. And so what's interesting here is this is ICE removal data. And as you will see, the percentage of people with criminal convictions that are the people that are getting removed has been stable for the last 8 years. It's been very similar, with criminal convictions being the highest percentage of people being removed. And it's important. One of the things I wanted to talk to you about is about what the current policies are and what they have been. So for over the last decade, or more than a decade, immigrant crime victims. So when I talked earlier about filing the victim's immigration case earlier, the VAWA, the T, the U, SIJS, any of them, those signal to the Department of Homeland Security that the person that somebody might be calling with a tip about is a crime victim. And crime victims have been protected from removal there's been a victim witness policy that has protected victims of removal in place for over a decade. The new policies that came out on September 30th, 2021, basically guarantee say the following, that the only people that are, so being undocumented in the United States is not a grounds for removal at this point. It's a grounds for removal, but it's not a priority for removal. The people who are priorities are people who are terrorists, people who entered the United States after November 1st, 2020, people apprehended in the process of trying to cross the border unlawfully, and people who are a current threat to public safety due to serious criminal conduct. And in that last one, they're looking at an individual assessment of totality of the circumstances, the gravity of the offense. Did it involve a dangerous weapon? What was the degree of harm to someone? And do they have a serious criminal history? If somebody is in one of these three groups, they will also consider mitigating factors. And the four top mitigating factors are being a crime victim, being a person who's likely to be granted humanitarian or other immigration relief. So that is all your VAWAs, all your Ts, all your Us, SIJS children, battered spouse waiver applicant. All of those people are going to be both crime victims and likely to get immigration status. They're also going to look at the impact of family members and loss of a caregiver or a provider on the family, and other factors as well. But what's really important to understand is you're not a priority for removal unless you fall into one of these priority categories. And even if you do have, let's say, even if you do have some kind of a conviction, they will still look at the totality of the factors. And that for crime victims, it is for many parents who are undocumented, it will not be a priority for removal anymore. And for immigrant crime victims, particularly, that will be true. So the fact that an individual, this is a quote from Secretary Mayorkas, is removable as a removal non-citizen, therefore should not alone be a basis for an immigration enforcement action against them. We will use our discretion to focus enforcement on in a more targeted way. Justice and our country's well-being require it. And this is from
Leslie.
Yeah.
Sorry, Leslie. I have a question about this because we have victims in our courtrooms that are victims of trafficking or of abuse, and they're oftentimes their pimps run them in, or traffickers run them in to stores to have them shoplift. They have, in some states, they still have prostitution as a crime on the things. They shoplift at the direction of their abusers. So what about victims like that who do have a criminal record?
So you could have somebody, let's take the shoplifting or the prostitution charge. So they might have they might be considered, let's say, maybe a public safety. They're not border security and they're not terrorism, those two crimes. And they're probably not public safety. A shoplifter is probably not a public safety crime, but let's even assume that they were. If you can show a connection between the abuse and the crime victimization, plus their crime victimization, you'll be able to overcome that in these cases. So those kinds of crimes are not going to lead to, and not likely to lead to, an immigrant victim's removal, or an immigrant parent who might be before you, their removal, because they have these mitigating factors.
So it's important then, if you have a client or a case before you, that you look at the underlying circumstances, because just because they have a case doesn't mean they're not eligible for that relief. So let me ask all of you now, in what percentage of your cases involving battered immigrants do you think the victim would be a high priority removal?
And here, do we have
I don't think we have a poll for this.
I think we do. Do we, Al? Yes.
Good. Yay. Okay, so just put it in the poll, please.
I'll take a sip of tea while we're waiting.
Yeah. Put in your answers. We're getting a lot of responses here. And what percentage of your cases involving battered immigrants would your victim be a high priority for removal?
Okay.
So this is interesting to me.
Okay, shall we end the poll and we can talk about it? Okay.
Yeah. Yeah, let's do it. So to me, because I thought
your video is breaking up, Rosemary.
There. What do you think about that, Leslie?
I couldn't hear. Your video was. Try it again, Judge Collins. So you're frozen. Oh, there you are.
Yeah, now there I am. Yeah, I know.
Okay.
I was frozen. It says my internet connection is unstable. Always.
Okay. So
Leslie, what do you make of this response?
So I think, it looks like most of you, other than about 8% of you, the cases that you're talking about, most of your clients will be not a removal priority. And those few that could be, let's say you have a victim who committed domestic, she retaliated, no, she didn't. Let's say you had a victim where, she was acting in self-defense and scratched her abuser and then took a plea to a domestic violence charge based on that. Those cases will be cases where, when you look at the totality of the circumstances, even though they might be arguably a hyper priority for removal, there is a way to address that in this totality of the circumstances analysis that could lead to even that parent not being a priority for removal. Judge Collins, how does information about protected areas from immigration enforcement, how might that be helpful to family courts?
Well, that's really important to family courts. Yeah, I can hear you. Can you hear me?
Yes.
For now, anyway.
Yeah.
Hopefully. Okay. I am having trouble with my internet. So it's very important. One of the bread and butter issues that we do is we exchange children from one parent to the other. And we do this in almost every one of our orders in family court, or at least a lot of them. And it can also happen in orders of protection. So it's important that we know where a safe place would be to do this, because we don't want to put the child or the protective immigrant parent at danger in any one of these spaces. So it's important that we know what is a protected area. And here's a list of some protected area where you can have the child exchanged at a shelter, a rape crisis center, supervised visitation issue, family justice centers. We have one in our community. So there are really important places that can provide for the safety of the child and the safety of the immigrant parents, because we know too many times parents will try to use the exchange as a place where somebody could be swooped up by ICE. And so there are areas that are protected from immigration enforcement. And that's important because you'll get people complying with your exchange orders, and you'll get parents then that realize this is not the place to play games, which reduces the trauma that children have to experience. And I think anytime that you can argue for the stability of the child and reduce trauma for the child, that's a winning argument in front of a judge.
So we're going to dig now a little bit more deeply, and I just want to say that it includes schools and universities, health clinics and mental health clinics, places of worship. So there are lots of places that you could go to do safe visitation exchange where immigration enforcement isn't supposed to happen. So we're going to dig a little bit more deeply into the myths and facts we were talking about earlier. For further information, we have information on our web library, and we'll send you the link in the materials, along with the materials we'll send probably after the webinar.
So I'd like to ask now, who is the least likely to flee with your child from the United States? I think we have this in a chat in the poll. Good. So who is the least likely to flee with the child? We're getting good response here. Everybody's clicking in. Who's the least likely to flee?
I think we have a pretty experienced audience.
Yeah, we do. You're getting it right. Yeah, it's. We can go to the next slide then.
Or actually, let's just share the results. And okay, basically, right. 65% of you said the undocumented mother. That is true. Multiple people with multiple entry visas, people that are dual national parents, and people that are U.S. citizens are the most likely to flee with children, because they can come and go from the United States as they wish. And and so they're the most likely. And that an undocumented mother it's very hard to re-enter after you leave. And so very few leave.
That's right. So it's important to know that that your legal and naturalized citizens are more likely to flee than the undocumented worker or parent. If there's been threats of kidnapping, then you should pay attention to that, because if somebody's willing to make a threat, then they might be willing to do it. Dual nationals, they can travel freely to and from the United States, and so they're more likely to do that. And I think you can verify this by looking at some of your news stories. We have news stories about a child being taken out of the country. Look and see who takes that child. It's somebody who has access to getting out of the country. And the Ninth Circuit found that there's no evidence that undocumented status correlates with the unmanageable flight risk. So that's important when you're doing your brief. If somebody said something about it, then that's a legal decision that you can quote in your brief to support your position, along with all the research that Leslie's done. So the risk of foreign-born parents with children, they are, and that's the next slide. When you assess them, you consider that whether the parent has previously attempted to abduct the child, has threatened it, have engaged in activities. It's really easy to see if somebody terminates their lease or closes out their bank accounts. That's real strong evidence, and they might be getting ready to go. If you've engaged in child abuse, those are people who don't really care about the safety of the child. They're really more concerned about themselves, and so they're likely to take the child. If they've refused a court order in the past, or if they have strong family or emotional ties to another country, these are all risks of child separation.
So, Judge Collins, what should be included in court orders to prevent international child abduction or reduce the risk of a parent fleeing with a child?
I think it's important that the court orders say that is a stated purpose of the order. So judges shouldn't be afraid to say, I'm concerned about the safety and welfare of this child and the child being taken from the jurisdiction of the court. And therefore, because of what reasons, and then say, therefore, I am ordering, and you can order that they turn their passports in if they have passports. You can say that they should say that the parent may not take this child outside of the jurisdiction of the court, including they can't take them on airplanes, they can't take them on boats, they can't take them on a cruise ship, they can't cross the border. And then you have to ask the judge to sign an order, and then you'll have to register that order. And I think, Leslie, you've done this before where you've registered orders with embassies or things like that. Is that correct?
Yes, and I've worked with lawyers who have. So once you get the court order as a lawyer, then you have to get it to the right people. So there have been cases, for example, in DC, where a judge said nobody should take the child from the country in their order, and then the lawyer or somebody provided, maybe it was Coach Social Services, I'm not sure, a copy of the order to the airport police, to the airlines, to and to the local police. And there is a case in which the child was literally taken off the plane twice based on the judge's court order. So that can happen, and but you have to be willing to ask for the orders, and then you have to be willing to try to implement them.
And don't underestimate the risk. If a parent tells you they're concerned about the child being taken, take it seriously and make sure you follow through to get the protections for that child and the parent that you need. So let's do this true or false question at this time. A parent with legal immigration status must be awarded custody in order to sponsor their child for legal immigration status.
Question. The answers are coming in.
Yeah.
And while the answers are coming in, somebody is mentioning in the chat, and it's true, that you can register if your child is a U.S. citizen. If you want to prevent the issuance of a passport to that child, you can register them with the State Department, and it will stop either parent from being able to get a passport for that child without notification to the other parent. It's just recommended.
Actually, I think most of,
go ahead.
Oh, sorry, Liz. I didn't mean to talk over you.
No, go ahead.
Well, I took my son for a passport when he was younger, and they said I couldn't get one without without the spouse there.
Right.
So they're being very careful about that.
Right, exactly. So as to the poll, if we can end it now, there about 88% of you are saying it's false, and that is right. A parent doesn't need immigration status. You don't have to have custody to be able to file for immigration relief for your child. All kinds of immigration relief. And we have a giant visa chart that we need to make sure in your materials, where you can look up the answer to this for every form of immigration status you can think of, about whether or not a child can be sponsored as part of that application. And we figured that all out for you. Next slide. So
the next question.
Yeah, go ahead. Judge Collins?
So, yeah, I was just going to go to the next question, but you may have something else you want to say about this.
No, that's fine. That's good.
There we go. All right. So what options might be available to a battered immigrant whose abuser seeks custody, claiming that the victim has no livelihood. So answer this if you would. What options are available?
So child support, spousal support is first option. Victim files immigration case and gains work authorization. There are public benefits available that the child or the immigrant parent may be eligible for, or all of the above. We'll give you a second till we get close to 50% of you responding. Almost there. I feel like I should say going, right? Great. So share the poll. All of the above is true. Judge Collins, are these the kinds of things that you've ordered or that you understand as a judge? Or?
Yes, and it's important for that because, and judges need to know about this because they should know that when victims file for protection, that they are on a path to get work authorization. They can get a driver's license. There's greater access to state benefits, and they need to understand too that their application is confidential, so their abuser can't learn that they have filed for this release. So these economic relief is very important to the courts, and it's important. It's an important issue to raise because judges like to make sure that people can be economically viable themselves and how they can help them be that way. So that you don't want somebody making an argument that these people are a drain on the system. They can't get jobs. They just need public aid all the time. They just want us to take care of people. And I'm not making that up myself. I've actually heard that. And so it's important that you be able to address those issues and say no, and here's why, and show them that the path to economic relief is a way to make sure that the societal system isn't overburdened, but that children get the protection and help that they need to go on and live normal, healthy lives. So I think we've covered when victims file for crime relief. Is there anything else on that?
So
why don't we go on to your side?
Okay, so I'm on the Inma Angelica case in Nebraska, just so you know where I am. Okay. So basically, this is an excellent case that has really good, this was a termination of parental rights case in which an immigrant mother ultimately got her children back. It's a long story and it would take a little while to present, but the reason I put it here is that there's really good language in a unanimous decision from the Nebraska Supreme Court that basically says that parents and you can cite this in your briefs to family court judges in custody cases, that all parents have a constitutional right to care and custody of their child, absent unfitness. This applies to all families without regard to undocumented status, whether the immigrant is in detention or has been deported. There's an overriding presumption that the parent-child relationship is constitutionally protected, and it's in the best interest to be with the protective natural parent. And that judges who might be tempted to and might be led there by the perpetrator's counsel should not be doing a comparison of countries and cultures and say, of course, it's better to be brought up in the United States than living with mom in Guatemala. Or making presumptions that mom's going to be deported to Guatemala, which we now know are not true. Those kinds of things. And there's just really good language that the court says about it really should be focusing on that protective parent and the child without regard to immigration status, detention, or deportation. Sorry, I went the wrong way.
And it's important to be prepared for those arguments because they will make them. The abuser will make them if it's pro se. But their attorney will make him too, not because, they could be making him out of ill motives, but they may not even know what the correct law is. And so these are some of the latest trends in the case law that says an undocumented status doesn't make an individual a flight risk. So when you're writing your briefs, these are cases to look at they often say that immigrant parents can't get an employment relationship. And you know what, as they said here, independent contractors have thrived all their lives. I frankly am an independent contractor now that I am retired and I'm doing consulting work. That is not something that people can use as an argument against awarding custody to an immigrant. Risk of deportation, many times that the risk of deportation is really, really extremely remote. And so that shouldn't be considered by a judge as reason to not give custody to a protective parent. So these are all good decisions to look at when you're helping a parent in court.
And we have a tool for you that we just published. We have an older publication that looks at all the cases prior to 2013 and a new publication that looks at cases reported from 2013 to the present, that you can look at these trends and get full copies, linked to full copies of the court cases we were just talking about. If you happen to be working with an immigrant parent who's in detention or gets detained, you need to know that there is a detained parent directive that orders ICE to essentially bring the parent to court or make the parent available for court proceedings involving their children. We do lots of technical assistance on this if you have questions. We're now going to turn...
Protective us.
Yeah, there we go.
Protection orders and custody. So let's go to our next question. In your jurisdiction, how often do judges include custody awards to the abused parent in protective cases? So if you can, is this a poll? Do we have this in our poll?
I think so. I don't know.
Good. All right. So
Yes.
if you don't have an answer, if you want to give us other responses, you can write in the chat, but do the poll. In your jurisdiction, how often do judges include custody orders to the abused parent in protective order cases?
Okay. And the results? It's about a third of you in. So it looks like only 8% are saying never. About 50% are saying often, over 90% are always, and about 43% are saying sometimes. So Judge Collins, what are the advantages of or you're supposed to ask me that, right? Sorry.
Yeah, that's right. That's right. Well, what are those advantages of litigating custody in the protection order?
So I did it in my practice at IUTA all the time. I mean, I'd say 95% of the custody cases I litigated in protection order proceedings. And it was very, very helpful because, one, the judge is focusing on the abuse, and we could really connect the need for custody with the protective parent and the abuse and mitigating the impact of the abuse on the child. But also, it basically, by doing it as part of the protection order case, almost every single later on when we filed the full custody case, they all settled so that we didn't have to litigate it again. And you got the orders in place sooner, which was much better for the victim and for the child. So Judge Collins, what are best practices for state court judges with regard to custody and survivors in protection order cases?
Well, it's best that you actually do them. And I know that in some jurisdictions, they split protection orders from family court. Some jurisdictions, they don't. But it's important that the child get the stability that we talked about, and that the protective parent also gets the recognition that they can, in fact, provide for their child. And it's important message to the abuser that the courts understand this abusive behavior, and they're not going to allow children to be affected by that as much as the abuser would want them to be. So it's important to provide that as soon as you can in a case. So even though some judges resist doing custody awards in protection cases, by putting up more hurdles to a victim who comes into the system, that you have to go file it in this courtroom or you have to go file it in that courtroom, you're not serving the children in your jurisdiction. So judges need to make those decisions as quickly as possible with the information they have, so that children can be protected. And that's judicial leadership.
So a couple of points on protection orders and on child support as we close out today. All persons are eligible to get a protection order without regard to immigration status of any part of your child. Issuance of a protection order has no effect on the immigration status of anybody. Conviction or finding a violation of protection order, however, is a deportable offense. So it's therefore super important that victims who were not perpetrators of abuse in the relationship don't agree to issuance of a protection order against them, because it puts them one step away from potentially being deported. And so it's really important not to agree to those, and there doesn't have to be a criminal prosecution for that danger to happen to the victim. The deportation ground gets triggered when it's the protective provisions of the protection order that are in jeopardy. So, for example, if the perpetrator didn't return grandma's clock, or consistently brought the kids back late from visitation, those aren't the deportable offense type of protection orders. But stalking, coming to a place where he was ordered to stay away from, physical abuse, threats, harassment, are all violations of the protective provisions. So what does this mean for judges, Judge Collins?
Well, what it means is that really we shouldn't do mutual orders. I know most jurisdictions have provisions that say you can't do mutual orders, but we all know that it does happen sometimes. But if you're representing a victim, you should make sure that, like Leslie mentioned, that you don't enter into an agreement that says, well, you get an order of protection against me, I'll get an order of protection against you. And so make sure that there's no order of protection entered against a victim unless there's actually grounds for that order of protection to be entered. And it's important that judges issue Padilla warnings. And what that means is you've got to tell somebody who has an order of protection against them what the consequences are for violating that order, and that can have significant impacts on their ability to remain in this custody or to seek immigration relief in this custody. So make sure that your courts do issue that, and if they don't, make sure you advise your client and make sure they acknowledge that, because you want to make sure they understand it. So many of our attorneys get written acknowledgments from their clients as to their admonishments about the effects of an order of protection violation on their immigration status.
So what's really important too is something somebody put in the chat, is that protection orders, many protection orders issued to immigrant victims who get protection orders while they're still living with their abusers because of the wait times to get work authorization under the VAWA and the U visa program. And so those people can get protection orders that basically they're no abuse protection orders, that they order no unlawful contact between the parties. And those can be very effective. We are going to be doing, our next webinar is likely to be on protection orders, and we're going to dig into all of this in much more depth. But in our last minute here, I just wanted to mention there are a number of different creative remedies that you can include in a protection order. And that, my pages are out of order. Oh, well. And you should consider doing that. But from a child support perspective, the last point I want to make is that getting court-ordered child support through the court is extremely helpful for both the immigrant non-custodial parents and for immigrant custodial parents, because both of them can use it as evidence of good moral character when they apply for naturalization, cancellation of removal, or any kind of relief in immigration court. And victims can show that it's a way that they're trying to take care of the perpetrator, the children's needs. Lack of legal immigration status is not a valid defense to non-payment of child support. Courts can order support, but not job searches for undocumented parents. A non-custodial parent can obtain an ITIN and pay taxes. But you should be aware that criminal convictions for failure to pay child support could be a deportable offense. If I may, Judge Collins, I'll just go through this last one. Wage withholding is a good, safe way to order child support in these cases, so both parties have a record of what was paid and what was received, which helps the immigration cases or naturalization cases of all of them. And that there's some very creative ways you could prove a non-custodial parent's income. We have a bench card on economic relief and a whole chapter on this on our training manual that we'll distribute as part of the materials. So in closing, and I apologize for the interpreters for speaking so fast. In closing, this is where the materials will be, and we'll send you a link after the webinar. Please call us for technical assistance if you have questions or are working your case and you want assistance. Judge Collins talked about the National Judicial Network. This is how judges can sign up to join the network. And at the second to the last thing I want to ask you is to consider joining if you're a family law lawyer. We have a community of practice that meets once a month for family lawyers, and we have a victim advocate community of practice that meets every other month as a way to have ongoing education and communicate with other people around the country who are doing similar kinds of work for immigrant survivors. And we encourage you to join those, and we'll send you those links in the follow-up materials. So I want to thank you, and please ask that you fill out your evaluations. I want to thank Elle and the National Council of Juvenile and Family Court Judges for sponsoring this event and for staffing us here, and thank Judge Collins for all your great insight and help with us on this webinar. And I want to thank all of you for the great work you're doing with immigrant survivors out there. Judge Collins?
Yes, thank you very much. Your work is really important. People need help, and they need somebody who knows what they're doing. So what you're doing to educate yourself and to help your clients is really outstanding. So thank you for joining us, and good luck to you in your practice.